Cybersquatting, or as it's sometimes called, domain squatting, occurs when someone in bad faith registers a domain name which matches either your name or your business name or your trademark with the intent to profit off the good standing of the name of your name or the goodwill you've generated amongst the community and in business. It's important to distinguish domain squatting, which is unlawful, with domain investing, which is perfectly legal. Domain investing would occur when you register a generic name, such as in the 1990s, if I had registered shoes.com, I probably would no longer be working. I'd be retired very comfortably because someone would have eventually come along and paid me a lot of money for that domain name. However, there are some gray areas that need to be decided through one of two processes that are available. One process to claim or reclaim a domain name from someone that is unlawfully squatting on it is the Uniform Domain Name Resolution process. That is an arbitration procedure that was created by a treaty passed through the World Intellectual Property Organization of the United Nations. That process is an arbitration process where the claimant can elect to either utilize a one arbitrator panel or a three arbitrator panel in order to decide the issue of whether it is unlawful domain squatting and whether the claimant should be entitled to the domain name. It's a very plaintiff-friendly forum. The one negative aspect of it is that there are no money damages available. So to the extent someone has been profiting off your name or mark through domain squatting and you want to recoup that money, then you would need to use a court procedure. That court procedure, at least in the United States, is provided by a federal statute, the Anti-Cybersquatting Protection Act, or the ACPA. That is, of course, a more drawn-out process. It's a more expensive process, and there is, of course, less certainty going through any court case. However, to the extent you are seeking money damages, it is available as a form of relief at the end should you prevail. However, the ACPA has been found in the past to only apply to individuals over whom the U.S. courts can exercise personal jurisdiction. So one example I am aware of was when Kevin Spacey attempted to recoup a domain name through the ACPA process, but I believe the individual was, the defendant was residing in Canada and the court declined to exercise personal jurisdiction over the individual. That's why, generally I say the UDRP process is favorable. It uses an alternative dispute resolution system. That's what arbitration is. Another form of ADR would be mediation. But the UDRP process does use arbitration, which is supposed to be final and binding. You get a decision and all parties are bound to it. Should you win the UDRP process, then ICANN, the Internet Corporation of Assigned Names and Numbers, will transfer the domain over to you. Just a few illustrative examples to see how this works, how the arguments flesh out. There was a case brought by Madonna back maybe 20 years ago or so where she did not own the domain name Madonna.com. She had a domain, I think her website was called Madonna Fan Club or something like that. Somebody had bought the name Madonna.com, and instead of putting images of the pop star or even the Virgin Mary or anything else that Madonna would refer to, he chose to display porn on the site. Now, the whole idea of that, at least as was found through I believe it was the UDRP process, was that was done in bad faith because it was a cheese in the mousetrap type trick that he had laid out. He wanted Madonna's fans, especially young fans, to end up on that site, and then they would get angry and Madonna would be motivated to pay him a lot of money for the site. Ultimately, Madonna stood on principle, didn't cave in to those demands, took it through the process, and ultimately prevailed. Conversely, things did not work out the same for Sting, who wanted to claim the domain name sting.com. However, someone was legitimately using that domain name, not trying to benefit off the goodwill of the singer or even the professional wrestler named Sting, but rather was simply had registered a website that was using a very generic name. And that doesn't mean that Sting can't, ultimately gain control over that domain name. It just means that he had to pay the person a bunch of money for it.